Do you find that people are happier when they mediate the case as opposed to a couple that actually went through the court system in the traditional manner?
I don't research that, but I know the researchers who do the research find that unequivocally folks who get divorced through a mediation are the word happy is a bit of an oxymoron in divorce, but they're far more content. My mind goes to a mediation, 33-year marriage. We finish up the first session. The husband looks at me and says, gee, that wasn't nearly as bad as I thought it would be. I find that literally I'm able to get 60 to 70% of the divorce-related issues done in one meeting. So the mediation process itself takes a lot less time, a lot less money, and it's a lot less aggravating. That's not to say that there aren't painful moments and painful mediation sessions, but they're contained. And rather than hiring a lawyer to get involved in a he said, she said dance in front of a dispassionate court, there's an opportunity for people to air their differences in a controlled and fair setting.
You said very quickly that the cost of getting divorced under mediation is less expensive than otherwise. Is that the case in all instances?
In every instance for me. I would say, because I do litigation as well, and I've never run the numbers, but I would say that on average, a mediated divorce is at least 80% less than a litigated case. It's 1/5 the cost. Saying that should not be the primary reason for choosing mediation, although it obviously is one of the reasons. There's a reason why those lawyer jokes are so funny. People should, in my mind, shouldn't always turn their destiny and their lives and the lives of their children over to lawyers. I know Judge Steinberg, I don't think he's practicing anymore. Before he meets at the special masters, he's known to say before a trial, do you really want me to determine what happens to your children? Do you really want me to determine what happens to your money? And he says it much more eloquently than I could, and he talks about that for about 20 minutes. He really scares people. And that's why they have such an enormously high success rate in the therapist-lawyer mediation program up in Hartford.
Now, when I first introduced you, I told the audience that in addition of you being a mediator, you also are involved in what they call the collaborative divorce process. Could you explain what the collaborative divorce process is and how it differs from divorce mediation? Sure.
About 15 years ago, here in Fairfield County, I started the Fairfield County Collaborative Divorce Group. We were finding that there were many people in Fairfield County who liked the idea of mediation, but did not like the idea of being unrepresented in the process, particularly women married to financial service guys. Women were just not comfortable with the imbalance of power, the imbalance of financial acumen. We've had enormous success with that. I know in my own practice I have anywhere from 4 to 6 or more collaborative divorces at any one time. It's a mediation-style effort in the sense that everyone meets, we discuss the issues around a table, and we work really hard to resolve the issues. Comparing that to the adversarial setting, it's far more effective, efficient, and friendly. And my sense is, and I've talked directly with both mediation and collaborative clients, that people are far more satisfied with the effort and the process and what they're able to accomplish. And they're also enormously pleased that they did not do further damage to an already damaged family, and the cost of their pocketbook was relatively minimum compared to the horror stories told to them by their friends.
Other than each party having an attorney, is there any other difference that distinguishes mediation from collaborative law?
Well, you've got 2 lawyers in the room, 2 parties, so the dialogue is much more free-flowing. One of the tenets of some people who practice collaborative divorce is that if the process breaks down, the lawyers are automatically out of the case. Some people make that part of the collaborative divorce practice. I don't. I really discuss that thoroughly with my client, and we make that decision. You sign on to not go to court. There are no formal papers that are filed with respect to discovery motions, interrogatories, requests for productions, or depositions. I think the primary difference between mediation and collaborative divorce is, again, each party has their own lawyer who is involved in every step of the way. And for many people, they want that. And it provides a necessary level of comfort for he or she to proceed with their divorce in a non-adversarial setting.
When an individual or two individuals sign up for either collaborative law process or the mediation, and it doesn't work out, I have two questions. Number one, what do you find are the most prevalent reasons why it doesn't work out? And second, once it's evident that it's not going to work out, what alternatives do these people go to? Do they go directly to the court system? What is your impression on those two questions?
I was talking about this the other day with a colleague. I can't recall a collaborative divorce not having worked out in 15 years. And I don't know if my experience is the norm or not, but all of the ones that I've had have worked out. Some have been incredibly difficult, really because of the level of hostility between the parties. In several instances, the unmitigated rage, and in other instances, the personality disorders that we were having to actively deal with. So I've had mediations that break down, and again, they break down because a client really can't tolerate, in some instances, the proximity to their spouse in the room. There's a sense of entitlement. I don't want to say too much, but I recently was involved in mediation, several $100 million, and one of the parties was unhappy with the way it was going to be allocated, and that broke down because one party had a totally different sense of fairness than the other party. So usually a mediation would break down because it becomes clear that there's a personality disorder or a psychological issue that I just don't have the skill set to navigate in a mediation because I'm not a psychiatrist or a psychologist, or someone has an unjustified sense of entitlement that can't be accommodated however hard I try in the mediation. And then in all the instances that I know of, people went to individual lawyers. They either went to court to have a judge decide, or the attorneys were able to negotiate it. Again, mediation is not for everyone. Not everyone can sit in a room after suffering for 2, 3, or 30 years in a very painful marriage and sit down and talk reasonably in an effort to resolve all the divorce-related issues. It's delicate business, to say the least. And again, it's counterintuitive that people are able to do that, but many are. And I think it's only on the rise. I've seen an uptick in the number of mediations, certainly in the number of collaborative divorce cases that I've handled in my practice over the last 15 years, and the climbs have been steady.
As a forensic accountant, I'm often retained sometimes as a neutral party by the court, and now often as a neutral party, as you explained in the mediation process. And I recently had a case in which the husband had a business, and all of a sudden the business was rather successful, and they lived very nicely for the 15-plus year marriage. And in the 2 or 3 years prior to the divorce, the business was not performing as it did historically. And the couple went into a mediation for the purpose of divorce. And the husband was a very, very A-plus type personality, a real control freak. And it was apparent that he was agreeable to go into the divorce process through mediation because he thought that he could control the process. He could control the attorney mediator. He could control the forensic accounting or therapeutic experts that were going to be retained. And that wasn't the process. That's not the result at all. Do you find that being common in your practice?
There are a number of people, usually men. I would imagine it has to do with the fact that we're in Fairfield County and a lot of people work on Wall Street, who have chosen mediation because they believe they can get over on their wife and they can control the process and control the outcome. I tell people early on in the consultation that my job is to strike a balance. I tell them that invariably one of them won't like something that I've said or suggestion I made or recommendation, and there will be other times where the other spouse doesn't like it. So yes, some people, frankly, choose mediation for the wrong reasons, primarily because they think they can control the process and get a deal that's more to their benefit than their spouse's. And some people may not know that coming in.
In a mediation or collaborative divorce environment, do you find that the end result is more often or less frequently appealed or modified than in a traditional divorce process setting that's involved the court?
A litigated decision is far more likely to be appealed than a mediated or a non-adversarial separation agreement, because in the mediation, in the collaborative divorce, even in a negotiated settlement, the parties and the lawyers can really control the nuance and the subtleties of the agreement. There are things in a mediated or non-adversarial separation agreement I could never get from a judge, even if I asked him or her, and it made perfect sense to craft the decision that way. Also, a case goes up on appeal for two reasons: an abuse of discretion by the trial court, or the court misapplied the law. In a non-adversarial separation agreement, there's often a far more thorough and careful vetting, and the parties and the lawyers know a lot more than a judge. A judge is hearing testimony over several hours, whereas in a mediation or a collaborative divorce, parties are working together for many, many hours to reach an agreement that really fits everybody's needs.
In a traditional divorce setting, there's the discovery process, there's depositions, there's other meetings with the court, status conferences, etc. Does the mediation and or collaborative process have these segments to their process with agendas and deadlines and requirements for the parties to meet?
The only requirement we have in a mediation or collaborative divorce is that imposed by the court, and that is we need to file a case management agreement in Connecticut in 90 days from the return date. Other than that, we do not do any formal discovery. We don't have depositions. The discovery is informal. Obviously, an inherent element of a mediation or collaborative divorce is that everything is transparent. It's open kimono, pockets out. I tell people anybody gets any documents they want, and if any documents are not provided for any reason, the mediation or the collaborative divorce is terminated because it's obvious that someone is not acting in good faith.
Well, Alan, I want to thank you very much for joining us today on Forensic Perspectives. Our guest today has been attorney Alan Rubenstein of the firm Halloran and Sage in Westport, Connecticut. If you have any questions for Alan regarding matrimonial or family law matters, he can be reached in his office at area code 203-222-4301. As always, our audience is welcome to contact our offices with any questions and comments. Stay connected with us on the web at www.msgcpa.com, where you can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. We have actually blogged on this topic, and our blog's address is www.forensicperspectives.com. So if you have any further interest in this topic, you can see that writings. Your topic suggestions for future broadcasts are always welcome. Until our next podcast, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA, PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.